Morning, Mayor, please, court. Yes, please, 5 minutes. Good morning, my name is Gary Edinger. I represent the Appellants. Those are Citrus Park Mall owner and whole property group. This case, for the most part, is a very straightforward and very ordinary case about interpretation of a reciprocal easement agreement, which is kind of the mall operating agreement, and also the usual kind of arguments you see in any summary judgment case. There were disputed issues of material fact. In this case, appellants maintain the very core issues were all hotly contested. But I think that if there's a novel issue in the case or something that warrants oral argument, it is the indispensable parties issue. So this was the lead argument in the appellant's brief. It was brought to the attention of the trial court, both through preservation in an affirmative defense and through a motion for judgment of the pleadings. The trial court below said that the other signatories to the reciprocal easement agreement did not have to be joined to this action, primarily because it was a declaratory judgment action brought under Chapter 86. Appellants maintain that the indispensable parties are the other signatories. So this is a mall, and so the other signatories are basically the big box owners and tenants.
What does the record reflect as to who's still there? Signatories. It's a shell of what you
well, you know, malls in general, this particular company, I should say, Your Honor, specializes in distressed malls and tries to reinvigorate. Every mall in America might fit in that category.
Amazon.
Yes, Your Honor. In direct answer to your question, I cannot recall if it was in an affidavit. It was in the pleadings, I believe, and then argued. And so, Your Honor, it is Macy's, Dillard's, Penny's, and the two successors to Sears, one of whom is Master Collision's land. So those are the other signatories in addition to the current owner of the mall, which is the Citrus Mall owners.
Well, would you agree in 1998, Sears was the only anchor tenant granted 2 parcels?
That's correct.
Okay. And 1 parcel was specifically constructed and designed for an automotive center.
Yes, Your Honor.
And every signatory agreed to.
Exactly right.
Thereafter.
Yes, sir.
So no one ever came in, whether Macy's took over for Dillard's, took over for Brandeis, no one ever sought to reform or rescind that REA to prohibit automotive repairs and what Sears was doing, correct?
Absolutely right.
Sears goes into bankruptcy and they sell this property in 2019, correct?
Yes,
And they sell to Realty 21.
correct.
So we're talking about an out parcel right here, away from the mall, that was specifically constructed and designed with huge doors, auto bays, things like that. So clearly you could look at it and say, I think they work on cars.
Sure,
Right.
we probably all have experience with
Okay.
these Sears
And
automobiles.
you'd also agree with me that the other anchor tenants, the non-signatories you're talking about, their only property interest is inside the air conditioned enclosed. Correct?
I would dispute that to some
How
extent.
so?
Right.
Does it indicate that they have any property owners interest or control over that detached building that was owned by Sears, now owned by Realty 21?
Right. Only through the reciprocal easement agreement.
Yes, which means they can drive by it. And they can walk over to it. They can
There's
complain to it.
there's also the restriction on use, which is restriction on use, Your Honor, which is kind of a traditional restrictive covenant.
Union 5,
Yes, sir.
those are just limitations. They're very, very specific limitations that were drafted in 1998. They went to a lot of trouble to specify exactly what they couldn't do. They couldn't do auctions, they couldn't sell, they couldn't lease. But there's absolutely no reference whatsoever to Sears in that detached building.
There is certainly a list of directly prohibited
Sure.
uses.
That has nothing to do with automotive repair.
Fair enough.
Well, we do have an issue perhaps about whether the scope of master collision work is a little more extensive than what Sears was doing. I saw something about it wanting to expand to be a collision center.
Right, which is the heart of the issue below, Your Honor. So the issue in terms of fact, which we maintain are highly disputed by conflicting affidavits, the usual thing we see in summary judgment. The issue is, are they in fact the same use? So sure, they both repair cars, but are the uses similar enough where the other signatories to the reciprocal easement agreement don't have a say-so in the anticipated use? So as we argued below, the evidence that describes what the collision center is going to do from Master Collision's side is nil. It simply says, we're going to do a collision center. This is our business. We do collision repair and auto glass.
But instead of taking a deposition of someone, you put up Miss Hatcher, who we've all practiced law, but she was kind of non-responsive. She didn't want to answer the questions. Kept looking at her board, but finally, when she answered the questions, she said, I had intimate knowledge about Master Collision and what they do. But I was not present to observe what Citrus Park Sears auto operation did, but I feel like I have an understanding. She never saw what they did. Never. And the extent of her knowledge of what they did was Master Collision was based on her review of websites and company representation.
Let me give some pushback on that.
And that's a testimony, sir, straight from the transcript. I read everything.
Very good. Then you also have read some other aspects of her testimony where she explains what the sources of her personal knowledge are. And then one thing I want to emphasize in particular.
But the source of personal knowledge, how do you attest to saying personal knowledge when you've never, ever visited the Sears Auto Center and actually observed what they did?
Right. So she has been to the Citrus Park Mall. She knows that facility very well. She would not have actually seen the Sears TBA in operation because it had ceased operation. But she's familiar with Sears operations, these tire, batteries, and accessories, TBAs in other locations, including other locations at malls operated by Hull. She also is familiar in particular with Master Collision facilities because she has seen those in operation herself. One of the key aspects of her testimony, which we rely on rather heavily, is the observation that you do not see collision repair centers at malls. They don't have them in any of the other whole property malls. They own 35 malls across the country.
I understand that, but you would agree that both Sears Auto Center and Master Collision are licensed under 559 as automotive repair. One might be louder than, but there's not much louder than a pneumatic foot taking tires off like Sears was doing.
Agreed, Your Honor. They're both repair facilities. They both work on automobiles. That's the nature fundamentally of what they do. The question is, what is the intensification of use if there is an intensification?
But you couldn't articulate the intensification other than banging out dents when she has no idea how that's done.
Well, she's not an automobile. She's not a mechanic.
Which
But-
leads me back to what I just said. We have no deposition testimony from anybody at Master Collision about what exactly they're going to do and how much noise it's going to cause. And whether any of their work is going to bleed out into the property and into the street. The other signatories have an easement. Zero.
Right. What we have, Your Honor, is a determination by the mall owner, in this case, done by a whole property group as the managing agent, that the use is not compatible with a first-class mall. That's the factual decision made by appellants in this case.
Okay, so let me ask you a question. Obviously, they agreed in 1998 that a use for a first-class enclosed mall was Sears Auto Center. Correct.
Absolutely correct.
Okay. So now we're talking apples and oranges as to what MCR does and Sears does. That's what you're saying.
Exactly
Rather
right.
than apples to apples.
Exactly right. So the reason why we maintain, there's a list of things that the appellants say that they went through, these that they would point to as differences in terms of the kind of use between a Sears TBA and Master Collision. And they involve in particular the fact that you have inoperable vehicles, the fact that you would have drop-offs instead of the kind of thing that used to happen in Sears.
So this was all speculation. This was by someone who's not even in the business.
No, Your Honor, she's in the business of evaluating
She's the
malls.
vice president of acquisitions. She
Right.
works in the financial office and she's never been to see Sears. nor she ever visited a master collision repair.
That is not correct based on the record. She has seen master collision in operation, and she is familiar with Sears TBAs, but not at this particular location. Those have been previously closed.
Well, also, when she was asked to identify what motor vehicle repair was on by Article 5.144, she only said, "You shall not use the site for trucks." I've looked over that clause is not in there.
Yes, Your Honor.
Lease trucks, and you can't sell trucks.
I think that was an error, Your Honor. That was,
But that's who you're on.
we're all human, Your Honor.
Yes, sir.
Fair enough. She
Who
was.
allegedly has the most knowledge concerning restrictions.
She does, Your Honor. And we maintain that because these are factual issues and the intent of the REA is clear in terms of maintaining the quality of a first-class mall, regional shopping center, that these are the kind of things that should not be determined on summary judgment. I understand Your Honor has a view of this case, and certainly the trial court, I think, probably shared that view. Our perspective, Your Honor, though, is that because it's a disputed fact, the judges shouldn't be making those decisions in the first instance. It is a jury question.
But if you're saying it's an issue of fact, then you must be arguing that this 5.1.4 is ambiguous.
No, Your Honor. We maintain rather that the appellants made the correct decision.
Then it's a decision of law.
No, because it is still always founded in fact. So we have an expression of intent. It's not appropriate for a first-class mall. But then you have to apply the facts. What is appropriate for a first-class mall? And is the anticipated use of this place as a collision repair center consistent with that image or what they're trying to maintain in terms of use? That's
back to the indispensable part.
sure.
Statute allows a joinder, but in a discretionary manner.
This is an interesting question, Your Honor.
Follow it up with the
You-
tag.
You bet.
It seems.
That was my question.
Yeah, it seems that every signatory could come back later on and say their interest in that declaration is impacted. And that just strikes me as a crazy way to run a railroad, so I did read it.
Yes, Your Honor. Frankly, this is the issue in the case that interests me as a practitioner. So we maintain that the ordinary laws for indispensable party would typically require the joiner of signatories to a contract. Similarly, when we're dealing with restricted covenants, which is basically what this use agreement is in this context, it's like a restricted covenant. We would join the people who are going to be affected by that covenant, who are signatories to the covenant. There might be an exception, for instance, when we're dealing with condos or homeowners associations, because they have like a designated representative that can stand in and effectively bind that interest. Here, that's not the case. We have independent signatories. They have their own independent defenses and issues and interests. And typically, in any given case, we would expect them to be joined in the case and then bound by the judgment. So we know that the standard for indispensable parties is hard, it's pretty high. And it's not just a matter of inconvenience, the fact that you might have multiple litigations because parties not joined or not subject to res judicata. But the law does contemplate that when we have signatories to a contract, they all be joined as indispensable parties. So how does this relate to?
All the cases you cited don't seem to be on point because Parmenia was the dispensability of the putative owner of the investment fund.
Right.
Which was the issue of the suit. Century Insurance addressed the debt action of the act coverage, insured and insurer. Lauderdale Boatyard, there was an error because the trial court awarded an implied easement which was not pleaded by either party. And the Altman case dealt with rescission of the transaction. The law holds that an action for rescission of transaction of parties to the transaction is indispensable. Here, we have anchor tenants in an unclosed air conditioner. In this document I looked over, they don't have any other interest in that parcel that Sears owned other than right of egress and ingress. That's what you argued below. I want to know, how else are they directly impacted by this court's decision about what you can do in that small confined space that is away from their property.
Right. That is the nature of the restrictive covenant, which
Well, no,
affects you.
how are they directly affected? They
You
can
should-
still get their goods and merchandise delivered to them, correct?
Right. So for purposes of access, because the easement does address access, we're not arguing that access is impaired.
Okay, so what's the direct impact? I really mean that. I'm curious.
Sure.
Well, we don't know, because if there's an increase in intensity in the property, that may very well, what was speculated has an impact on the interior wall tenants.
Right. Well, that's exactly right, Your Honor. The concern is that
Are we
it will.
supposed to decide on speculation?
No, Your Honor. I understand that you're skeptical of our proofs.
No, it's not skeptical, sir. I just don't see the evidence because you put up a young lady who's in an office who doesn't know anything about the operation of Sears or the operation of MCR. She testified, sir, I can show you, that her knowledge of master collision repair is based on what she read on websites.
I
And
do,
the company presentation.
I do understand your point, Your Honor. I would like to, if I may, circle back to the indispensable.
16, use your.
Okay, let me do that.
Can I interrupt because they both have been just admitting rebuttal. It still goes back to Judge Rose asked the same question that was on my mind. That this is made it's more permissive. What's in this record? And all the other signatories that you're claiming are indispensable. Because this dispute just appears to me only your or their interpretation of descriptive. And so the other parties, unless there's a complete adjudication of their rights under the certificate covenant, then you could say that this is an indispensable party. I'm just, under this record, I'm having a hard time with that. I just wanted to throw that out, give you the opportunity to address that.
Right.
Okay?
Let me address it now. Let me run into my rebuttal time. I think that's a better use for our present conversation. So, Your Honor, in our initial brief in particular, we emphasize the fact that this reciprocal easement agreement does a lot of things, has a lot of hats. What we're dealing with primarily is like restricted covenants and the people who contracted to be bound by that restricted covenant. We cited a number of cases, including U.S. Supreme Court, and I think Loxahatchee was one of them, which go to the idea that contracting parties are supposed to be joined as indispensable. So I think the interesting question presented by this case is, does section 86.091 somehow affect that balance or maybe loosen the standards that we would generally apply for indispensable parties? So in the Century National case, we went to one extreme. The party argued that because of some loose language and some very ancient case law that suggested that interested parties had to be joined in a DEC action. And this court correctly said no. The party there was a tort claimant. The court ruled properly they were not indispensable, and then went on to say there's nothing about 86091 on its face that requires that joinder because it uses may as permissive. And then, as Your Honor notes, and Your Honor also notes, that parties not joined are not going to be bound by res judicata. They can litigate their own interests, which is kind of a crazy way to go about the system. What we have here is an equally extreme interpretation by master collision, but at a polar opposite, the exact opposite direction. That because of this permissive language, it would excuse the joinder of parties who would ordinarily be indispensable in a case. And we would maintain that that's asking Century National to do too much. Century National doesn't proclaim that it's going to be overturning the law in that way. And we see, for instance, in Parmenia, also dealing with the declaratory judgment statute, that the ordinary rules of indispensable parties apply. And so, Judge Sleet, when you were suggesting that we can distinguish these cases on the facts, well, yeah, they all deal with different facts, but the legal principles are what we're dealing with here, and those are universal. And so, in closing on this issue of indispensable parties, judges, it's the appellant's proposition that all the signatories are affected by this use because the mall will be downgraded in quality from appellant's perspective. and that they are indispensable under the ordinary rules that apply in all cases, and that 86091 does not affect that determination. Thank you very much.
Again,
Good morning, Your Honors. Alicia Whiting Rosage on behalf of Master Collision Repair. I will pick up where you all left off with the indispensable parties argument. This is a deck action. It is a very limited in scope deck action. We've asked the court in the underlying case to determine what NCR's possessory interest, how can it use the out parcel, as Judge Slate noted earlier, whether we can use that for continued use of motor vehicle repair.
Well, let me ask you a question, because it's clear that the out is part of first class enclosed mall. Based on documents.
That is correct.
No, it's physically detached. So. Whatever use occurs at that detached building has some kind of effect upon the anchor tenants, correct?
Correct. I don't disagree with that. That's not, the standard is not do you have an interest? Because if you take that argument to its logical conclusion, then every single tenant in the mall could come in, all the internal could also make that same argument. And you've never heard counsel for the appellant say, well, then they should have also named all of the tenants, because when you're looking at a deck action and what the statute says is parties who may have an interest. But with respect to indispensable parties, it's not those parties who may have an interest, but those parties to whom an adjudication cannot be made without their presence. And when you're looking at the specific issue being argued in this case, which is how can the tenant continue to use the Sears Auto property as an automobile mechanic shop? Going back to what you said earlier, Judge Slate, is back in 1998, they agreed it could be used as an automobile center. Now, if for instance, they decided later it was too loud, then certainly the tenants and or the anchor tenants in this particular case can come back and say, well, we need an injunction because it's a nuisance. But under the code case, specifically, it says simply because there might be additional lawsuits later does not make necessarily those parties indispensable. And in this particular case, it's a very limited declaratory relief are we seeking. Does NCR, as a tenant, have the right to continue to use the out parcel as an automobile facility?
And
We're not asking.
And I'm reading the case law correctly, that in order for someone to be considered indispensable, is that there has to be, and I wrote this down, a complete adjudication of the rights under the restricted covenants. And so here, the dispute, the deck action that was filed, as I see it here, is between NCR and the defendants. Over their interpretation of restricted covenant.
That's correct. If, let's say, let me give you an example, because sometimes it's easier. Let's say that my client came in and moved to rescind all the restrictive covenants, to get rid of them altogether. I think that would be a different story, right? Because then at that point, we are adjudicating the rights, because and there's a case that talks about in the case of contract rescission, you're basically doing away with the contract. So then you are adjudicating the rights of the parties to that particular contract. And the reason for that is because then you have due process problems, right? And you're taking away somebody's rights under the agreement. We're not taking away anybody's rights under the agreement. We're simply asking the court to interpret what that language, activity of a type, means relative to the dispute that has arisen only between Master Collision Repair and the appellants, Citrus Park Mall, and Hall Property Group.
so if your client is going to expand the scope of the TBA and do collision work, let's assume for the moment that would be an increase in intensity. Why would the other signatories not have an interest in a possible expanded scope of operations?
So I'm going to answer that in two phases. First of all, I challenge this idea that an intensification of use is somehow restricted under the restrictive covenants. Right, so let's go back to what restrictive covenants, how you analyze those. You analyze those against the party trying to enforce it in favor of the free and unrestricted use of the property. Nowhere in that restricted covenant does it say, the property, Sears Auto out parcel shall be used for automobile repair, limited to brakes, tires, and batteries. Nowhere does it say that.
What it did.
There's no evidence of that. There's no evidence in the record of that, and as a matter of personal experience, I will dispute that, but, you know, but I didn't sign an affidavit, so that's not for the court. So the restricted covenant, then, because look, I mean, if you go back and look at the restricted covenant, let me give you an example that's in the language itself. So there's two. One says Sears Auto can have a rental car kiosk, and they're the only ones who can have a rental car kiosk, and you'll be limited to 20 parking spaces. So that was one explicit restriction. Another restriction was we will have restaurants, but no fast food restaurants. So they restricted the type of restaurants that could be at the mall. A third one was you cannot have dry cleaners, but you can do pickup and drop off. So you can't have a dry cleaner that processes the clothes on site, but you can do pickup and drop off. And so when you're dealing with restrictive covenant and you're taking away people's property rights, you have to be explicit in what you're limiting. So to suggest this because somehow you're taking off a bumper versus taking off a tire, that is a different use. As a matter of law, that is not a different use. As a matter of 55903, right, the Florida legislature has defined motor vehicle repair as expansive to include both taking off bumpers and taking off tires. They make no distinction. So to suggest that somehow there's a restrictive covenant that prohibits intensification of a use, or I don't know, a welding machine versus a pneumatic air gun, there is no language in the covenant to do that. And therefore the court rightfully did not imply that the restriction was there, because it has to be explicit.
But that deals with a covenant and in juxtaposition with the statute, it really is independent of the indispensable party. I'm not clear, I guess, but that I see the issues.
Yeah, so going back to your question then of an intensification of use, I'll go back to what the deck action statute says, which parties who may have interested parties may be brought in, but they don't have to be brought in. And again, I go back to this idea of we're not adjudicating JCPenney's rights as to the use of its parcel. If I were, they would have to be brought in as a party. We're not adjudicating Dillard's right to use its parcel under the restrictive covenant. If we were, I would have to bring in Dillard's. What we're adjudicating is whether or not my client, the tenant, can use the Sears Auto property continuously as a motor vehicle repair facility.
Potentially, as I said earlier, it's a crazy way to run a railroad. Potentially serial lawsuits by the signatories.
And that's the code case. That's the CHOATE case, which says it might be a crazy way to run a railroad, but under Florida statute and Florida law, you can run a crazy railroad or as permitted. And so, it may not be the most efficient, but the law is not always efficient. And it doesn't necessarily change what constitutes or who constitutes an indispensable party.
So what evidence in the record is there? And this is what concerns me. I don't have a position in this case, despite what you say. The only thing you did was you put a young lady who's only been there 12 years to testify about MCR and Sears Auto Center without any personal knowledge. So tell me, man, because I'm concerned, what evidence in the record is there that MCR's work is so destructive and so intensive that it is unlike what Sears was doing in any way, shape, or form, and it's going to be noisy, cause all kinds of problems. Inoperable vehicles are parked on the side of the road, on the grass, whatever. I just don't see it in the record. Is it there?
There is absolutely zero record evidence that there's been an intensification of use. What you have in the record is you have testimony from corporate representatives of MCR, saying that it is I think it is like a high-class pollutant repair facility. You have testimonies that says that they're going to be replacing glass. There's testimony, but not testimony, there's question.
What were those opinions based?
The opinions, well, they're not opinions. So you had,
Because this lady, her affidavit under oath said, I have intimate knowledge of master collision repairs operations.
she had no personal knowledge, and quite frankly, I took notes. On page 1523 and 1524 of the record, you'll see that she testified that she had never been inside a master collision repair facility, and that she'd only ever witnessed it from the outside. That's in our briefing, and that's on the record 1523 and 1524. So you have there was no opposing evidence presented by the appellants in this case. There wasn't, because none of the testimony that they gave, they laid the foundation for it.
So any conclusion we can draw as to whether this would indeed be a nuisance is based on speculation, is it?
It's speculation, opinion, feelings, all of which are not evidence. Now, what you do have in the record relative, we did establish as a matter of law that master collision repair is an automobile repair facility. We established as a matter of law that Sears is an automobile repair facility. And so based on the evidence before the court, it is the same activity. They are conducting the same activity, motor vehicle repair. And so, this idea that they are different, there's simply no evidence for that.
And I saw the record that master collision repair does not intend to remodel, expand, or do anything to the existing structure.
They are going to, well, they have to do some remodeling. I mean, the plans,
Yeah.
they have to paint it and things of that nature. I mean, the plans that are attached show, I mean, right now there were no bays. They took the bays out, so they put the bays back.
Well, they're not gonna have ramps with cars up on top outside.
No, Your Honor, no. No, and again, there's no evidence of that presented either. I mean, there's this idea, again, the young lady testified that, well, in her affidavit, well, there are gonna be disabled cars and everything in the parking lot. There's no evidence of that. She didn't have any basis for that, because again, she's never been to a master collision repair, and she just doesn't know what they do, and she doesn't know what Sears did when they were there. I mean, there was no evidence, because one of the things that she says, stated in her affidavit was the motor vehicles that go to Sears were operable. They were driven in and out, and they were there for less than an hour. There's no evidence. There's no evidence of that. There's no evidence of the condition of the cars. I mean, if you take her testimony, you would think that they were Mercedes-Benz sitting out in the parking lot all the time, ready to go, and these beautiful cars. I mean, that's just simply probably not the actual reality, whether it goes to a Sears or a master collision repair. So you probably drive through the Citrus Park mall parking lot. It's have all kinds of conditions of fixed up cars. So indispensable parties. We believe that in this particular case, and I just want to circle back on the idea of the restrictive covenant. It really is on the party trying to enforce the restrictive covenant to establish the limitation. And you do that by way of putting the restriction in the restrictive easement agreement. You do that the way that they did in 1989, 1998, when they drafted this, by specifically saying what you don't want. You don't want dry cleanings. You don't want fast food restaurants. You don't want rental car businesses, but okay, Sears, you can have one, limited to 20 cars. And when you don't put in there, we don't want a motor vehicle repair facility other than the Sears, and we only want Sears to do tire and battery and brakes, then you don't get to come in 20 years later and say, well, I don't like the fact that you might remove a bumper. I don't like the fact that you want to remove a piece of glass. And so now I'm going to try to use this catch-all provision, activity of a type, and say, well, we don't like this type of activity, despite the fact that it's a continued use of the property to prohibit an otherwise permissible use. Because if you allow the appellants in this case to do that, then what stops them from going to dealers when they sell the property, and maybe the new the new business is selling a different type of clothes. Well, we don't agree with the type of clothes you're selling. Yeah, you're selling lingerie. We Dillard's didn't sell lingerie. Now you can't sell lingerie because it's a different activity, right? Because it's a different type of product.
Well, it does restrict selling of clothing outside their doors.
It does, but I'm talking about what happens inside the doors, right? So if Dillard's were to sell and they, just, and this is a crazy background, but if Dillard's were to sell and they never sold lingerie and a new company comes in and they're selling retail, but they throw in lingerie, then what stops the owners at this point from saying, well, it's a different activity because you're selling lingerie and we don't like that, as opposed to, sweatpants. I mean, that's really what's going on here. We don't like the fact that you might take off bumpers. We just want you to take off tires. And that's really arbitrary. And I think you guys hit the nail on the head when you talked about the evidence. We presented evidence by way of affidavits, request for judicial notice. All of those were accepted by the court and relied on the court. That was substantial competent evidence to establish that it is the continued use as a motor vehicle repair facility. They presented no evidence that it was a different use or even an intensification of the use. And so we would ask the court to affirm the final judgment involving the trial in this case. Thank you.
Thank you. I'm sure we've got a lot of questions about September.
Well, I figured I had like 20 seconds left.
No, I'm giving you 3 minutes.
Okay.
Too much, go ahead.
Thank you, Your Honor. I gotta say, I love oral argument, and I very much enjoy that interchange. You don't have that opportunity in any other aspects
We like
of our
it too.
practice. Thank you,
Some of
Judge.
these guys don't, we like it.
Your Honor, I've spoken my piece on the sufficiency of the evidence and the disputed issues of the fact. The precise relief we're looking for here, what we would commend to the court, would be reversal for failure to join indispensable parties. That would direct the court below to grant our motion for judgment on the pleadings. The other big box stores, the other signatories to the REA, would be joined into a single lawsuit. It avoids the train wreck problem, but is also consistent with the basic law about indispensable parties. And at that point, we have a full litigation. Everyone is joined by a final adjudication, maybe by summary judgment, maybe by trial. But the proper result is to have all the parties before.
Okay, so you're gonna write that, just hypothetical, you're gonna write that reversal. Or maybe it doesn't get you, because the investment fund manager was an indispensable party. Because it was his investment fund, so Century Insurance, theirs to join injured third parties, while they're blowing up both yard, well, Judge Peacock didn't award relief that wasn't pled. Altman felt the rescission of transactions. So, okay, you're writing this opinion. So far, what we have is Miss Hatcher saying, I've got intimate knowledge about all this kind of stuff. And based on this, REA do legal. So what are we going to say and articulate? What rights of Burdines and everybody else are directly affected by the declaration or his argument?
So let me, your question is really two things. What case law do we rely on that gets us there for the indispensable party? Because I got to write that part of the opinion. And what I would rely on there, Your Honor, is on the substance of it, not Century Retail, not the Parmenia case, but rather the line of cases that say that parties who are signatories to a contract, in particular with regard to restricted covenants, are indispensable and must be joined. That is the
ultimate. These are signatories.
There are exceptions. So for instance, with joint obligors on a note or guarantors, they don't all have to be joined. But in this case, the parties have equivalent rights. But we don't know all the defenses of the other signatories because they're not joined.
But I'll be first, they may have a possible right to file an injunction should this become nuisance out of everything else.
Right. Well, they have the same rights to enforce. So it would be injunction or deck action filed by Macy's, Burdines, or J.C. Penney's. And then with regard to, so the substantive laws are indispensable parties that have to be joined. And then in answer to your question about what interest do the other stores have? Firstly, on this record, we don't know because they're not joined. But one would think that they're equivalent to the interest of the appellants in this case, because there's no ranking of the signatories in terms of their rights under the reciprocal easement agreement. Thank you, Your Honor.
Thank you, it's good to see you. We are adjourned.
Thank you.
All rise.